Subscribe to the channel for more content. WAHT is Section 156 CrPC. According to Section 156 of the CrPC, the police are permitted to look into a criminal offense without a formal FIR or a magistrate's order. The magistrate can order an investigation if the police don't conduct one. The magistrate, however, cannot stop the police from investigating if they do so. Courts are prohibited from restricting or interfering with the police's statutory right to conduct investigations. When the police prefer a charge sheet following an investigation, courts may or may not take action, but their role starts at that point. The police are given extensive authority under Section 156(1) to investigate a crime without a magistrate's permission. The judiciary could not have interfered with or regulated the police's legal investigative rights. The police are not allowed to investigate if the FIR or other pertinent documents fail to make any cognizable offense appear to have been committed, at least on the surface. In such a situation, the High Court may halt and quash the investigation by exercising its inherent powers under Section 482 or its powers under Article 226 of the Constitution. The police can investigate cognizable offences outside their local jurisdiction per Section 156(1) s latter half. In the territorial jurisdiction case of Manoj Kumar Sharma v. State of Chhattisgarh, 2016, the court highlighted that Chapter 13 of the Code establishes jurisdiction of the criminal courts in inquiries and trials. It should be noted that the chapter, as mentioned earlier, contains many provisions that give the court the authority to investigate or try a criminal case, and that there is no absolute restriction on the investigation, inquiry, or trial of crimes committed outside of a given region or territory. By referring to Sections 177 to 188, this would be made apparent. It is evident from a reading of Sections 177 and 178 of the Code that Section 177 establishes an ordinary location for an investigation or trial. When it is unclear which of several local areas an offense was committed, or where the crime was committed, when the offense was partially committed in one local area and partially in another, or when it consisted of several acts performed in different local areas, Section 178 provides for a spot of investigation or trial. It may be investigated or tried by a court having jurisdiction over any of these local areas. Therefore, it cannot be claimed that the SHO needs more territorial authority to investigate the offense at this point in the investigation. However, if the officer determines following the inquiry that the reason for filing the FIR did not occur within his territorial jurisdiction, he will transmit the case to the relevant magistrate, who is authorized to take cognizance of the offense. No matter which officer leads the investigation to the trial, the case's outcome, conviction or acquittal, is unaffected. That is primarily determined by the evidence presented during the trial. Any improper or incomplete investigation of the crime does not invalidate the trial unless it causes prejudice against the accused or a miscarriage of justice. In Hari Singh v. State of Uttar Pradesh, 2006, it was decided that the complainant might bring the complaint before the magistrate if the police failed to investigate the incident. However, the complainant's writ petition asking the CBI to conduct an investigation is unjustifiable.